Greetings, Remax Distinctive Agents. It's Dan Bouchard Fernandez with another timely update for legal study and legal case studies. So we're going to bring to you a case situation here today that was brought up in Virginia, but it honestly applies to all the jurisdictions that we operate in. There are 4 articles of allegations, and here let's dive into the facts. So on April 2nd, buyer Matt Olson and seller Jesse Chavez entered into a purchase contract to buy real property. Olson was represented by Austin Riley, a salesperson who works for Chop House Real Estate, the listing firm. Chavez was represented by 755 Real Estate LLC as the selling firm. However, when preparing the contract, Riley inadvertently switched the listing firm and the selling firm on the contract. On May 8th, more than a month later, after the ratification of the contract, Riley delivered the settlement check to Chop House's business manager. The manager realized she did not have the contract for the transaction and requested it from Riley. Riley submitted the contract the next day. So keep in mind, Riley submitted this contract a full month after it was ratified. And he only delivered it at the point of settlement. When Brian Snitker, the principal broker for Chop House, reviewed the contract, he noticed that the EMD for the contract had never been received. Riley stated that Olson told him he had mailed the EMD, but had apparently not done so. So he was relying on the fact that his client told him it was mailed in, but he didn't verify anything. He didn't verify it and get factual proof that the deposit was actually made and received by the escrow agent. This is why we have the item in our checklist for that purpose. Riley stated that he wasn't aware the EMD had not been received until he was told by Snitker, as both he and Olson had been on vacation during the deposit window. Sorry, I was on vacation. Do you think that might have hold any water? Probably not with the Real Estate Commission. They don't care if we go on. The agent dropped the ball on this one. So the findings of the Real Estate Board found that for count 1, Riley did not exercise ordinary care when completing the contract, even though there was ultimately no harm done to the consumer. So remember, count 1 was the fact that they swapped the buyer's brokerage and the seller's brokerage. They flipped them around. So that was probably an honest mistake. It probably was an unintentional mistake. Nonetheless, the Real Estate Commission found that agent did not exercise ordinary care and was in violation of the law in that respect. So keep that in mind. That's count 1. Count 2, the administrative code, that's Virginia law, requires that agents submit to the broker in a timely manner all contracts for which the broker has oversight responsibility. So in a timely manner doesn't mean a month later. And so that's another issue. So just be aware that when you're submitting your files to the brokerage, just when the contract settles, you are already in violation of the law and could be held accountable by the Real Estate Commission if that were to happen. So just want to kind of emphasize that to everybody. So we really need to get those things in the hands of the brokerage. Your buyer agency agreements, your listing agreements, your tenant agency agreements, all of those things and the sales contracts need to be submitted to the brokerage immediately as they're ratified. All right. Next topic. So for count 2, the administrative code requires that agents submit to the broker in a timely manner all contracts for which the broker has oversight responsibility. Riley did not comply. By failing to ensure that the EMD had been submitted, Riley also violated the duty of ordinary care. So he was relying on his client to send in the earnest money deposit, but he failed to ensure that there was ordinary care given to ensure that the deposit was actually made. It was his responsibility to make sure of that. And then upon discovering that there was no earnest money deposited, it was also his responsibility to notify the opposite agent and in turn the opposite party in the transaction, as well as the escrow agent, whoever the escrow agent should have been, that was not in compliance, and then to immediately rectify it. He didn't do any of that, so that's another violation. Riley also violated the duty to ordinary care established in count 3 when he did not make reasonable efforts to ensure his client complied with the earnest money deposit deadline. Finally, because Riley did not make all parties aware that the earnest money had not been received, he was in violation of the regulation in count 4. So the sanctions on count 1, probation in 6 months, $550. Count 2, 6 hours of board-approved education in real estate law and regulations to be completed within 6 months, and a monetary fine of $500. So we now have $1,100 or $1,050 just for 2 counts, probation for 6 months, 3 hours of board-approved education and escrow requirements to be completed within 6 months, an additional $550,000, and for count 4, probation for 6 months and a monetary fine of $600. Riley received an additional year of probation. During that time, Riley and his broker must provide quarterly reports to the real estate board, verifying that Riley is in compliance with all the rules and regulations. So I don't want to see us getting into these kinds of things. So if we could ensure that we really get our listing agreements, our buyer agency agreements, our escrow deposits to the escrow holder, whoever it is, and our contracts in on time as soon as they're ratified, then we can avoid all of these fines and disciplinary measures. Thanks so much and have a great day. Cheers. Onward and upward.